As we do each and every morning, we track what's going on with various lawsuits challenging gun laws, not just in Illinois, but across the country. And we've got something that we talked about yesterday in the case challenging the ATF's rule on gun parts like lower receivers or frames that are unfinished. And looks like we've got a court order that was issued yesterday after a oral argument in this case, Vanderstock v. Garland, back on Thursday. So let's go ahead and get into this, and you can sound off anytime at 217-629-7970. Again, 217-629-7970. It is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. And why are we looking at what's going on over at a case in California? Because it could ultimately lead to impacting how Illinois' cases turn out. Not directly, because the Ninth Circuit, which California is included when it comes to the federal appeals court, those rulings only impact the Ninth Circuit. But the plaintiffs in the case in Illinois challenging the gun and magazine ban have directed the judges on the Seventh Circuit Court of Appeals, where we're still waiting for an outcome, to look at other cases that are being decided by lower courts. In particular, they've asked that the Hawaii decision that says butterfly knife bans are unconstitutional. The plaintiffs in Illinois have asked the Seventh Circuit Court of Appeals to review that case in their ongoing deliberations about this. But now, also, after the Southern District's California case of Bonta v. Garland, that dealt with magazine bans, and that's being dealt with by the Ninth Circuit Court of Appeals. But Illinois plaintiffs have said, hey, look at this judge over here in California saying that bans on certain types of magazines is unconstitutional. So the plaintiffs there in Illinois are saying, look at that case over in California. Could they also have similar arguments when it comes to this case, Vanderstock v. Garland out of Texas, which is the Fifth Circuit Court of Appeals? So how that may impact any of the lawsuits against Illinois gun laws, I think it's important that we do understand that. But yesterday, after Thursday's hearing, and if you recall, we had the judge in the Fifth Circuit Court of Appeals with the Vanderstock case ultimately talking about how this case is, about gun parts and whether or not they're completely finished, and can the ATF actually just go ahead and, essentially have rules that are crafted outside of Congress making laws, regulating the parts and receivers and such. So one of the questions that the court brought up was, are you, the state, the federal government, the ATF, the Department of Justice, are you going to enforce this against just regular customers, people who aren't manufacturers? And the government said, no, that's not their intent to enforce this on those customers. They intend to enforce this on the plaintiffs. So they heard that Thursday. You heard those questions about how they plan on enforcing this. You heard a lot about the issue of vacating versus an injunction. This is, legal jujitsu of sorts, just the different types of things that could be done in courts. But you've gotten the Vanderstock case yesterday after Thursday's hearing having an order. And let's go ahead and take a look at that docket where you've got it lined up here in the Fifth Circuit Court of Appeals. And we'll get this just right for you if you're following along online. They ultimately ordered, and you can read that there on the docket, that they granted in part a motion to vacate district court's injunction filed by the DOJ, Bureau of Alcohol, Tobacco, Firearms, and Explosives, and Merrick Garland. The government's motion is granted in part. The district court's preliminary injunction is vacated as to non-parties, and the government's motion is otherwise denied. So what does that mean exactly? Well, if you click through on the docket and you actually take a look at the order that came out yesterday in the Fifth Circuit on this Vanderstock case. It goes through. It says the ATF promulgated a final rule that, among other things, changed the longstanding federal definition of firearm, frame, or receiver. A group of plaintiffs brought that lawsuit challenging two provisions of the final rule. The district court held that those provisions exceeded ATF's statutory authority and vacated the entire final rule. The Supreme Court stayed the district court's ruling insofar as they vacate the final rule. Two of the plaintiffs, manufacturers of frames or receivers regulated by the final rule, then asked the district court for injunctive relief pending appeal. The district court enjoined the government from enforcing the challenged portions of the final rule against the two plaintiffs and their customers. The government has now asked us to vacate the district court's injunction. It goes on to say that we agree the government that the district court's injunction sweeps too broadly. Injunction that afford relief to non-parties are potentially problematic. And those non-parties would be the just regular customers. It goes on to say, and it appears the district court's injunction sweeps too broadly insofar as it affords relief to non-party customers. That is particularly true because the government has been adamant in both writing and oral arguments on this motion that it will not enforce the final rule against customers who purchase regulated firearms or receivers and who are otherwise lawfully entitled to firearms purchases. Of course, if circumstances change, the district court is free to narrowly tailor injunctive relief to meet the changed circumstances. But as things stand today, the government is correct that the injunction cannot extend to non-party customers. But we agree with the government that the district court's injunction as to two plaintiffs' party manufacturers directly conflicts with the Supreme Court's determination that the government should be permitted to enforce the rule as to everyone while this appeal proceeds. Government vacatur. Motion 8, we have three reasons. First, the Supreme Court limited its stay to the global relief afforded to the district court's vacatur order. It goes on to read out the Supreme Court's ruling there. Then it goes on to say the Supreme Court could have simply stayed the district court's vacatur and judgments without qualification. Instead, the court stayed them insofar as they vacate the final rule. It goes on to say, second, we cannot say that the district court abused its discretion in granting traditional limited injunctive relief to the two parties. It goes on to say that the party plaintiffs' manufacturers would be irreparably harmed by being forced to shut down their companies or by being arrested pending judicial review of the final rule. It goes on to say that the party plaintiffs' manufacturers are likely to succeed on the merits because the final rule is contrary to law, and both the balance of equities and the public interest weigh in favor of allowing orderly judicial review of the final rule before anyone shuts down their business or sends them to jail. Goes on to say we are sensitive to the fact that the government is irreparably harmed whenever its rules are enjoined, and goes on to say that ATF changed the final rule. ATF's desire to change the status quo does not outweigh the few additional weeks or months needed to complete judicial review of the ATF's work. Thus, under a precedent set, any other standard, we cannot say the government has shown that it's entitled to emergency vacatur of the district court's injunction as to the two-party plaintiff manufacturers. So essentially what you've got here at the end of the day, they say we think four things are paramount. First, inferior federal courts must exhibit unflinching obedience to the Supreme Court's order. Second, the Supreme Court has directed us to be skeptical, if not altogether unwilling, to order universal relief that extends to non-parties. Third, insofar as possible, we should have orderly judicial review in which the status quo is maintained and the legal rule sorted without asking courts to make monumental decisions in short-fuse emergency dockets. Fourth and finally, courts should be able to review ATF's 98-page rule and the decades of precedent it attempts to change without the government putting people in jail or shutting down businesses. For these reasons, the government's motion is granted in part, the district court's preliminary injunction is vacated as to non-parties, and the government's motion is otherwise denied. So essentially what you've got here is them saying that, hey, we're going to go ahead and say an injunction is only good for the parties that are part of the suit, and that's the Defense Distributed and Black Hawk Manufacturing, who make these lower receivers that are unfinished, and they sell them. The ATF's trying to say those are gun parts, and you can't sell those without having a serial number or having them registered. So ultimately, that case is going to proceed, but the government can't enforce it against the manufacturers, and the government's already said they're not going to enforce it against customers. So that was issued yesterday in the Fifth Circuit Court of Appeals. We will talk about the Seventh Circuit Court of Appeals case and particularly the issue of a case that's coming up next week down in the Southern District. That's part of the challenge in Illinois against the state's gun and magazine ban. So we'll get to that.